What should I do for written discovery? What interrogatory should I serve? Are there form interrogatories? Does anybody have a special set of interrogatories in blank case? Hi, I'm Saul Gruber from Gruber Trial Consulting, and we're here to talk to you a little bit about interrogatories, how to use them, and maybe not the best way to use them. First of all, what's an interrogatory? You all know this. It's written questions that can be served on defendants when litigation starts. Now, depending on your jurisdiction will depend on what you really should do with these form questions. Some jurisdictions limit the amount of interrogatories, and others will even have something called form interrogatories in a regular personal injury case, a medical malpractice case, that are being served automatically and then give you certain amount for supplemental interrogatories. Take everything with a grain of salt, depending on what jurisdiction you're in. However, one key thing with all interrogatories is who is going to answer them. Although they're served on a party, we're all too experienced to think that the party really answers those, correct? It is the lawyers that answer them, and they're normally answered with an objection. Then a lot of legal speak, whether it be overbroad, burdensome, privileged, something that says why they don't have to answer the questions. In certain cases, the lawyer will then give a qualified response, but there's always that objection looming. And that's really the problem with interrogatories, is there are questions that are served on lawyers, not on people, not on witnesses. So when you're coming up with your interrogatories, think to yourself, is this better in a written form where a lawyer gets to answer, or in an oral form at a deposition when you're looking the witness straight away and they're looking at you and they realize they have to answer truthfully? There's a big, big difference. And I'll give you an example of what I'm talking about. In the medical malpractice and nursing home field, quite often we're looking for incident reports. We're looking for things of that nature. And the objection is what? Peer review, a qualified immunity, and perhaps there's even some statute in the particular state that says you can't get those incident reports. And now you're arguing, if you want to file a motion to get the incident report, and you're assuming that the objection that the lawyer gives has some relevance, and they're kind of framing that issue. However, if you ask the question of the witness, are there incident reports that are kept in a medical malpractice case? There may be an objection, but there really can't be an instruction not to answer, right? That answer is either going to be a yes or no. Okay, what is the purpose of that incident report? Why are those incident reports done? A follow-up question. What is the basis for the incident reports? How are they used? What are they used for? Are they used for future care of this particular resident if they're still in the facility? These are all questions you can ask, and by asking them orally, you're eliminating one objection after another after another. You can ask an administrator of a facility, would it impact resident care if you were to have to turn this over? No. Would it be burdensome to hit a button on your computer so that it could be emailed or put on a disk? No. Would it be a problem if we sent representatives from our law firm and a defense, and you put all those documents in a room and they're scanned, and nobody from your facility has to be burdened by it? Does that help? These are all questions you can ask rather than asking interrogatories. And I want you to think about that when you're coming up with the actual interrogatories you want to serve. That the interrogatory should be served so that there is an official request for a document that must always be amended when the document is found, right? You want to make sure that there's a request for charts, for policies, for pictures, no matter what type of case it is. And you're going to do that by way of interrogatory. So that's one reason why you have to serve interrogatories. The other is to gain certain information. And that information may be about third parties, such as, do you contend there was a management company in charge on the week of this incident? Do you contend that there was a snow removal company that was supposed to remove the snow during this day? Do you contend that there was a management company taking care of maintenance at this particular supermarket? You want to find out, are they claiming someone else is responsible? And if they say no, and later on come up with that as a defense, you now have a question that's been served and answered that you relied upon. That's kind of an important way to do interrogatories. The other thing we recommend to all of our clients is sit down and think, what do you really want to know? Be as distinct, as specific as possible in a small amount of questions. Serve them with your complaint. The concept of I'm going to serve 150 interrogatories, I never understood. You're going to have to read them. You're going to have to deal with the objections. You're giving yourself a lot of work that a simple deposition could take care of. So that's not something that I've ever understood, quite frankly. I always want to save a few interrogatories for the end of discovery in case there's something you want to clean up. It may be the last deposition, you find out something else. It may be something you want to find out about an expert witness. It may be something you just want to find out about evidence that you've adduced during discovery, but you don't want to take another deposition. So you always want to keep a few in your pocket to save. It's kind of like a jury challenge. It's really difficult to pick a jury when you have no challenges left, because you may think who you struck is a good person to strike, but then you have someone else that turns out to be worse. So it's really difficult. You always want to have that extra interrogatory in your pocket lane. Remember, leave yourself one or two left over for later, and don't bombard somebody with 100 to 200 to 300 interrogatories. They normally don't get you any more information. All they do is create work for the defense, and they love it. And you're going to be going to motion court. And if you're a motion court in every one of your cases, because you've filed excessive discovery in every one of your cases, the judges will begin to know that. But make this work for you. Know what you want, know how you're going to get it, and ask specifically for those documents. If you liked this video on interrogatories, please subscribe to our YouTube channel and look for our Nursing Home Minute, which comes out every other week. And remember, look for the podcast that's going to be dropping within the next 2 weeks. The Jury Thinks What? Thank you for tuning in. And if you need anything, please contact us immediately. Also, look for our next legal tip of the month. And there we're going to continue our discovery phase and discovery tips and talk about requests for admissions. That's something you don't want to miss. Thank you.